The U.S. Supreme Court delivered two decisions Monday. The court decided that the state of Arizona cannot require proof of citizenship of voters in order to participate in elections. Our guests are Katherine Culliton-Gonzales, who's director of the Voter Protection Program with the Advancement Project. She joins us from Washington, D.C., and our Arise News legal contributor is back with us again, and we'll talk about it, Seema Iyer. Thank you both again for being here with us. Thank you for the first time to you, Katherine.
My pleasure.
So let's talk about this decision by the Supreme Court. They basically said that states cannot require additional proof other than what is already allowed on the federal form. Is that correct?
Yeah, that's absolutely right. That the current federal form, where people attest to citizenship and where only eligible citizens can register to vote, is what preempts Arizona's Proposition 200 that would have required additional proof of citizenship when it's absolutely unnecessary. So it was a great win for voting rights. During the few years that Proposition 200 was in effect, over 30,000 people were rejected in their voter registration applications, and those 30,000 people are going to be able to get back on the rolls. So it's a great victory.
And it symbolizes what to you, Katherine?
Well, it symbolizes that, sometimes with the Supreme Court, cooler heads will prevail. We are waiting for another voting rights decision in the Shelby case, and we certainly hope that cooler heads will prevail in that case, too. So it was a day where, the justices followed the facts, they followed the law, they followed the concepts of free and fair and accessible elections that are at the heart of our American democracy. So it's a great victory in that regard, and we hope that the justices continue following the facts and the law and protect our most fundamental right in the upcoming case in Shelby County, Alabama.
Katherine, sit tight. I want to bring Seema into this discussion. This is a bit of a complicated ruling. It was a 7-2 ruling, and it sort of creates sort of a two-tier kind of situation for some states?
Sure, and although I'm so appreciative of Katherine's elation over this, what's disturbing me now is that, now 2 tiers in that, okay, for the federal form, the court is saying you don't need additional proof, but for the state form, that rule still applies, that in Arizona, you still need additional proof. Now, the other issue is, especially when Katherine was saying, cooler heads prevailing, actually what the court said at the very end of the decision was, oh, by the way, if you want to fix this, this is what you have to do. Go to the EAC, the Election Assistance Commission, excuse me, and go there, and that's your fight, okay? Change the form. That's what you do. And if that doesn't work, by the way, go to court and make another application. So I'm not really happy with this decision. I think it's kind of a guise of joy for immigration policy when really it's quite troubling.
Katherine, I hear you saying in there. Do you have a bit of guarded optimism there?
Yeah, no, I actually agree completely. So for now, it's very good for the 30,000 voters who have been unable to register or their voter registration was rejected in Arizona, but that's absolutely correct. The decision leaves the door open for future ways that Arizona and other states could require more proof of citizenship that's needed. And we are also at Advancement Project very concerned. We're a racial justice group. We know these kind of laws have a disproportionate impact on Black and Latino and Asian American voters and Native American voters. And yeah, it's written by Justice Scalia, so it's not, it's not a clear victory. It's an important victory for now, but in the future, this issue's gonna come back to the court, and groups like us are gonna continue to fight it because the ultimate reality is that we need free and fair and accessible elections, and that sometimes federal law should prevail, and we hope that it will prevail in the next instance as well too. But it's not a perfect victory. It's a good victory for now, but it keeps the door open for future disenfranchisement that we will continue to fight.
And that was my next question, Katherine. What does your organization plan to do next then?
We are keeping an eye on these kind of laws across the country. There are 4 other states that have similar laws, and 9 states are thinking about adopting them. And so we work at the state level to try to stop these laws before they even go into effect. And for those that are in effect, we're part of a broad coalition that litigates against them. We did bring a case in Florida last year against proof of citizenship, or against purging alleged non-citizens from the voting rolls. That turned out to be purging naturalized citizens. that turned out to be purging completely eligible voters, and we settled that very favorably. So we're going to keep on fighting the good fight and make sure that that the parts of this decision that are negative hopefully will not have a negative effect on voting rights.
Katherine Culliton-Gonzales, thank you so much for your time. I'm going to let you go. Really do appreciate it. Before I let you go, Seema, let's talk about the other ruling that came down that had to do with the Fifth Amendment and your right to remain silent or not, and sort of what the consequence is. Now your silence can be held against you?
That's right, Debbie. If you don't say anything, I'm going to shove it back in your face on my closing argument as a prosecutor.
So talk about the case and what the ruling was.
So what the judge said in this ruling, and it was a slim majority, 5-4. And what they are saying is that when you are being questioned by law enforcement before the Miranda rights, okay, so you're detained, they're asking questions, and if you're silent, if I say, Debbie, where's the gun? You don't say anything, then that silence, that answer to the question can later be used against you. And in what practical purposes? At trial. So let's say we go investigate and we find the gun and we tie the gun to you, that the fact that you said silence is almost you being complicit and agreeing. So this is huge. This is a huge, huge problem.
So where does this leave lawyers then?
Exactly. Where does it leave us now? What I think practically what we will be doing in every state of this country is that we will rely on the state constitution and we will rely on case law that says, no, silence can't be used against you. But practically speaking, okay, there was this great quote by Breyer where he said, what's the legal magic here? Do you actually have to say, instead of silence, I invoke my Fifth Amendment privilege? That's what it's saying, which is ridiculous.
Yeah. And here it is. We did put it up. It says, but does that really mean that the suspect must use the exact words, quote, Fifth Amendment? How can an individual who is not a lawyer know that these particular words are legally magic? There
is no answer to that question. Right now, the answer is yes. You have to say, I invoke my Fifth Amendment privilege.
Tricky.
If you don't then so my second solution is go with your state law and rely on the state constitution.
And have a good lawyer. Seema Iyer, thank you so much. We'll see you again soon.